In this video, we will do a deep dive into the felony sentencing process in the Superior Court of District of Columbia. My name is Brittany Bunch, and I'm the Outreach Specialist for the DC Sentencing Commission. We are the agency that implements, monitors, and supports the application of the District of Columbia Voluntary Sentencing Guidelines. In our previous video, we talked about the master and drug grids and how they are utilized using the DC Voluntary Sentencing Guidelines. We also explored the many resources in the DC Voluntary Sentencing Guidelines manual that help judges with the application of the guidelines. Be sure to check it out if you haven't already. If you're interested in learning more about the felony sentencing process, then you'll enjoy this video. Keep watching. The DC Voluntary Sentencing Guidelines recommend sentence types and a sentencing range for every defendant convicted of a felony offense in DC Superior Court. However, determining a defendant's sentencing guidelines range and sentencing options is just one part of the felony sentencing process. We will be exploring what happens before, during, and after sentencing in the district. Let's get into these steps using a hypothetical. In this hypothetical, the defendant does not want to take a plea agreement. However, plea agreements are very common in DC Superior Court, representing 98.8% of dispositions at a case level in 2021. Plea agreements can be negotiated at any time while a criminal case is pending. Each case may be a little different. After a judge accepts a defendant's plea, the case will be set for sentencing. So let's get into our hypo. On Saturday, August 20th at 4 p.m., the police were called to the scene of a carjacking involving a knife. The 911 dispatcher communicated to the police that the stolen car was a 2021 Honda Accord and provided the license plate number. The dispatcher also provided details on the attacker as communicated by the victim. The attacker fled the scene with the vehicle but was stopped several minutes later after a hit from a license plate reader. The suspect matched the description the dispatcher provided and was detained without incident. At the station, the victim identified the detained individual as the man who committed the carjacking. The detained individual was then arrested and identified as John Bravo, a 26-year-old DC resident. After his arrest, police transported Mr. Bravo to the local police district station for processing and completed his arrest paperwork. A statement of probable cause was completed by the arresting detective. Mr. Bravo asserted his Fifth Amendment right to remain silent. After declining to be interviewed by detectives, Mr. Bravo was transported from the district station to the Central Cell Block, CCB, below MPD headquarters. He remained at CCB until just after noon on Monday when he was transported to DC Superior Court. During the time Mr. Bravo spent at CCB, the United States Attorney's Office, also called the USAO, for the District of Columbia, reviewed the statement of probable cause completed by the detective, the evidence in the case, and spoke to the victim. Monday morning, USAO determined that they wanted to move forward with prosecuting the case and filed official documents in Superior Court charging Mr. Bravo with carjacking while armed. In DC, this process is commonly referred to as papering the case. On Monday morning, Mr. Bravo was assigned a public defender. His attorney talked to Mr. Bravo, reviewed his criminal record, and began investigating the case. At 3 p.m. on Monday afternoon, the court called Mr. Bravo's case and a presentment hearing was held. At the hearing, after arguments from the defense attorney and the Assistant United States Attorney, AUSA, A magistrate judge determined that the government had proven probable cause to show that Mr. Bravo committed the carjacking. The judge ordered that Mr. Bravo be held by the D.C. Department of Corrections, and a preliminary hearing was set. 1 week later, Mr. Bravo appeared for his preliminary hearing. During the hearing, the lead detective investigating the carjacking testified. Mr. Jock, Mr. Bravo's attorney, made arguments against the evidence presented at the hearing by the USAO. It is important to note that information called discovery is shared amongst the parties throughout the process, not at just one hearing. After hearing both parties, the judge determined that there was probable cause to move forward with this case. After the judge's ruling, Mr. Jocks moved for his client's release. However, that request was denied by the court and a date was set for the felony status conference in 2 weeks' time. The judge found that due to the violent conduct alleged in the defendant's prior criminal history, that included several misdemeanor assault convictions, he was a danger to the community. 4 days after the hearing, the USAO sent Mr. Bravo his first plea agreement. It is important to note that while many cases are resolved via plea agreement, there is no requirement that the government extend a plea offer. In this case, the government offered to let Mr. Bravo plead to unarmed carjacking. If he did so, they would dismiss or not bring any additional charges related to the incident. The plea also required that, if accepted, neither party would ask for a departure from the recommended sentencing guidelines range. After consulting with his attorney, Mr. Bravo decided to reject the plea agreement. During the felony status hearing, Mr. Jock and the AUSA updated the court on the status of the case. The AUSA informed the court that the case was being presented to the grand jury, that the government had begun turning over discovery, and that Mr. Bravo had rejected its plea offer. The judge had the AUSA read the plea offer on the record and confirmed with Mr. Bravo that he had the opportunity to discuss the offer with his attorney and that he was rejecting the plea. Mr. Jocks noted that he is looking into acquiring an expert to speak to Mr. Bravo's mental state and how it impaired him during this crime. The judge set a motion schedule in the case. Following the hearing, the AUSA provided a second plea offer to Mr. Bravo, which he turned down. Following the hearing, the prosecution brought the case in front of the grand jury. The grand jury heard the evidence and testimony collected. The lead detective assigned to the case gave testimony regarding the carjacking, identifying Mr. Bravo as the person who he apprehended in the stolen vehicle in this case. After hearing the evidence, the grand jury indicted Mr. Bravo for carjacking while armed. Mr. Bravo was arraigned 2 weeks later. At the arraignment hearing, Mr. Bravo was formally charged with carjacking while armed, which carries a mandatory minimum of 15 years, equaling 180 months. Another status hearing was scheduled for the following week. During the status hearing, the prosecution provided a final plea offer. Mr. Jocks worked with the AUSA to negotiate a potential agreement. After speaking with his attorney about the details of the agreement, Mr. Bravo decided to not move forward with the plea. Following the status hearing, the pretrial conference date was set. At the pretrial conference, Mr. Bravo's lawyer and the prosecution exchanged additional evidence. Also during this hearing, the USAO and Mr. Jocks argued the written motions they had filed that did not require witness testimony to resolve. The AUSA asked the court to prevent a defense expert from taking the stand. Mr. Jocks argued a motion to stop the AUSA from mentioning Mr. Bravo's previous juvenile shoplifting convictions. The date for the motion hearing was set 1 week before the trial. During the motion hearing, the judge granted Mr. Jocks' motion because the convictions were juvenile adjudications and declined the AUSA's request to prohibit Mr. Bravo's expert from testifying. During this time, Mr. Bravo remained in custody. Following the motions hearing, preparation for the trial started with picking a jury. Out of the 60 potential jurors sent to the courtroom, a jury of 12 district residents was impaneled to hear the case and 2 alternate jurors. Before trial, the judge explained to the jury that the burden is on the government to prove to the jury beyond a reasonable doubt that Mr. Bravo committed the crime. This is accomplished through USAO's attorney presenting evidence and testimony. Called as the first witness, the victim in this case took the stand and identified Mr. Bravo as their attacker, describing the incident to the jury, and was then cross-examined by Mr. Bravo's attorney. After the USAO rested for the prosecution after presenting all of their evidence, Mr. Jocks presented his case on behalf of Mr. Bravo. Mr. Jocks brought expert witnesses to speak to Mr. Bravo's deteriorating mental state during the time of this crime. Mr. Bravo elected not to testify in his defense after consulting with his attorney. The judge instructed the jury that they could not hold Mr. Bravo's constitutional right not to testify against him. After closing arguments and jury instructions, the matter was left to the jury to deliberate. After 2 days of deliberation, the jury found Mr. Bravo guilty of carjacking while armed. The sentencing date was set for 3 months later. As he was found guilty, Mr. Bravo remained in custody pending sentencing. In the time between the verdict and sentencing, the court ordered that the Court Services and Offender Supervision Agency, also called CSOSA, create a pre-sentence investigation report, also called a PSI. This report was done by a member of CSOSA's diagnostic team. The PSI contained detailed information on the offense of conviction, Mr. Bravo's criminal history score, and his personal life. Mr. Bravo was given the opportunity to speak with the PSI writer and make a statement in the report. The PSI writer also interviewed Mr. Bravo's family members, former classmates, employers, and friends to get a better sense of Mr. Bravo's background. The report also included his history of mental illness and educational level. Mr. Bravo dropped out of school at the age of 16. This report also calculated Mr. Bravo's criminal history score as 1 point and featured a recommendation that he should receive a prison sentence based upon the sentencing guidelines recommended sentence and the mandatory minimum in this matter. The report also delved into potential rehabilitative options, such as anger management groups and substance abuse counseling, that Mr. Bravo could benefit from following his release. This comprehensive report was delivered to all parties for review. Ultimately, the judge has the final say regarding the imposed sentence and criminal history score of the defendant. On the defense side, Mr. Jocks also gathered information from Mr. Bravo's family and friends so that they can make statements regarding Mr. Bravo and how he positively impacted their lives, as well as highlighted his mental health struggles. Mr. Jocks also created a memorandum regarding his recommendations for the sentence length. He proposed that the sentence imposed should be 180 months due to the mandatory minimum sentence, which is the lowest sentence available for someone convicted of armed carjacking. The AUSA, on the other hand, was also hard at work crafting a memorandum that included its recommended sentence, which was a bit higher than the mandatory minimum due to the seriousness of the offense and the impact of the victim. They also gathered community impact statements from community members negatively impacted by Mr. Bravo's behavior in the community. Additionally, the AUSA gathered a victim impact statement to speak to how the victim now suffers from PTSD due to the incident. After 3 months, the sentencing hearing was held. After hearing the case, reviewing the facts, and reading the PSI submitted by CSOSA, The judge sentenced Mr. Bravo to a guideline-compliant prison sentence of 180 months with no time suspended and the required 5 years of supervised release following the ending of his sentence. The judge also ordered Mr. Bravo to complete 2 anger management courses and attend drug abuse counseling once he was released. Following the pronouncement of the sentence, Mr. Bravo was taken into the Bureau of Prison Custody. Mr. Bravo had a right to appeal the case but decided against it. With good time credit, Mr. Bravo served 85% of his 180-month sentence. He was then released and started his post-release supervision with CSOSA. During his post-release supervision, he reported to his community supervision officer, also called CSO, regularly and passed all required drug tests. He completed his anger management course, attended drug abuse counseling, and acquired a job. After completing his 5 years of supervision, Mr. Bravo was released from supervision and his sentence was complete. If you like this video, make sure to subscribe to our YouTube channel. All you have to do is click on the subscribe button below this video. Also, be sure to check out our website at sentencing.dc.gov and follow us on our social media accounts. Links are in the description box below. Stay tuned for our next video. Now I want to turn it over to you. If there are any topics you would like for us to cover in upcoming videos, let us know by leaving a comment. Thank you for watching.